Good afternoon, everyone. It's my pleasure to welcome you to the Jerusalem Fund's annual Edward Said Memorial Lecture. And it's my honor on behalf of the Fund's Board of Directors and staff to introduce our distinguished lecturer this year, Wadie Said. My name is Zaina Azam and I'm the Executive Director here. Wadie, we're so delighted to have you with us today and that you accepted our invitation to deliver this important lecture. Before I introduce our distinguished lecturer, I would like to say a few words about Dr. Edward Said, who is Wadie Said's father. Edward Said is regarded as one of the most illustrious Palestinian public intellectuals. He wrote more than 20 books and was a passionate advocate for Palestine. Edward Said was an acclaimed literary and music critic and theorist whose seminal work, Orientalism, influenced generations of academics and scholars who study the Middle East and other non-Western societies. He died in 2003. We're all most proud of his ideas and analyses and writings, and therefore the Jerusalem Fund wanted to set up an annual event in his memory. We believe he would have been very proud and pleased with our choice of Wadie Said to deliver this important lecture in his name. Wadie Said is professor of law at the University of South Carolina School of Law, where he teaches criminal law, criminal procedure, and human rights law. Before joining the South Carolina faculty, Said represented terrorist suspects as an assistant federal public defender in Tampa, Florida, serving as counsel in United States versus Al-Aryan, one of the largest terrorism prosecutions in American history. A graduate of Princeton University and Columbia Law School, he clerked for Chief Justice Charles P. Sifton of the U.S. District Court for the Eastern District of New York. He's the author of the recently published book, Crimes of Terror, The Legal and Political Implications of Federal Terrorism Prosecutions, which provides a comprehensive legal analysis of the criminal terrorist prosecution in the United States. His scholarship also appears in many prestigious law journals and reviews. As the Palestine Center's Edward Said Memorial Lecturer this year, Wadie Said will discuss the issue of terrorism and the ways in which it's produced and dealt with in the American legal system. Terrorism laws and prosecutions raise essential questions about sacrificing constitutional rights and protections in the name of security. Indeed, Edward Said wrote in the preface of his book Orientalism that, quote, "Our role is to widen the field of discussion, not to set limits in accord with the prevailing authority," unquote. The title of Wadie Said's talk today is The Terrorism Label, an examination of American criminal prosecutions. He'll speak for about 35 to 40 minutes, after which we'll open the floor for discussion and questions. So please help me join me in welcoming Wadie Said.
Thank you all very much for being here, and thank you to Zaina for inviting me and for that very generous introduction. Because, while I've spoken at several events over the past 13 years in my father's honor, this is really quite an amazing honor, privilege for me to give a lecture in his memory. I think my sister gave this lecture a few years ago, but I'm honored to join the list of the very impressive speakers in addition to her who've given this lecture. Although I think today I might be saying something a little bit different outside the norm of what you may hear in terms of, or what you all might be used to in terms of how the law, specifically the criminal law in this country, implicates our concept of what terrorism is and sort of how it represents a threat, or how the government believes it represents a threat and how it's construed. Having said that, I think I should really note that it's always a bit of a strange experience when you have to reflect on someone's intellectual and activist legacy when you're also that person's son, you know. So, because I've also been shaped by my father in a personal capacity, and very much influenced by him, not just, you know, in terms of how I think and you know, my belief system, both as an individual, but also as it relates to kind of world affairs and matters of public concern. Because there is, in my case, I believe, a great deal of overlap between the two spheres. And I hope to make that connection in the words that I'll offer here today. My father's role in merging academic rigor with his political activism and analyses was something I always marveled at. And I think at the outset I want to say I think you all understand this and know this, he never really shied away from drawing lessons that were relevant in the Middle Eastern context, the Palestinian context, from other situations, other areas of the world. So, for example, something he wrote about, although I think, you know, it's important to re-raise it, is his 1991 trip to South Africa, where he met with members of the African National Congress, and he had sessions with Nelson Mandela and Walter Sisulu. And that trip allowed him to draw linkages between the Palestinian struggle and that of South Africans against apartheid. Unfortunately, when he tried to raise those lessons with the Palestinian leadership, they were reluctant to embrace them. But I think, you know, that's one example among many that demonstrate his kind of vision, his expansive vision, and his understanding of where struggles against occupation kind of lie on the spectrum, and how we can draw kind of support from other struggles in facing injustice. Back to me specifically, I think mostly I really absorbed the idea that one shouldn't cease in trying to help those who are truly marginalized and ostracized. And I think when I gave some thought to how I wanted to put this into action, you know, I think when I went to law school, I had ideas of being a human rights lawyer, you know, being involved in international human rights. And I think where I struggled was the idea that, you know, I don't mean to in any way put down the work that people in the international human rights field do, but I think there's some structural limitations or conceptual limitations. And I also think the idea of just writing reports wasn't something that appealed to me. So I thought to do something a little bit more, what I believe to be concrete. And that led me to try and work as a public defender. And interestingly, and sadly as well, in the fall of 2003, my father had only been gone, had only since passed away a few days earlier. I had accepted a position as an assistant federal public defender in Tampa, Florida, where I helped defend one of the accused in the prosecution involving the former University of South Florida computer science professor, Sami al-Arian, of Palestinian origin, and charged with all sorts of things related to his allegedly being active on behalf of a group called what the government called the Palestinian Islamic Jihad, what the group calls itself the Islamic Jihad movement in Palestine. It's very interesting, by the way. This is a complete aside before I get into the meat of my remarks here. But I'm not really sure. I want to raise this point just to kind of raise it. I don't know how important it really is. But, you know, when we think about things, especially when we talk about terrorism, things have to be translated. Phrases and terms need to be translated from foreign languages. And I think there are lessons to draw here in the sense that the government translates things the way it wants, not necessarily how they line up or how they're most properly translated into English, for example. And you see things like this. I'm going to talk a little bit about a case involving a fellow whose last name is Abu Ali. And, you know, if you read the Federal Register, one of the case opinions involving him is recorded as United States versus Ali. Now, you wouldn't have, and I think Americans would probably be rightly aggrieved if, for example, foreign countries referred to, you know, state or people versus Jackson as people versus Jack, right? It doesn't make any sense to just clip off whole parts of names. How important that is, I'll leave it to you. But you see that over and over in my line of work, translations rendered in funny ways, etc. Again, it's a small aside. I just raise it to highlight some of the things that you come up, some big, some small. In any event, the decision that I made to become a public defender, and that experience, which included several years of motion practice, plus a 6-month jury trial, which is unusual in the criminal defense business, exposed me to the government's criminal prosecution regime of individuals they believed were terrorists. And that is a regime that you may have seen over the years touted as the better alternative to the Guantanamo military tribunal model. Okay? Now, what I came to realize rather quickly that either-or comparison of terrorists deserve either military tribunals with very few protections, constitutional protections, or the better alternative, as it has been touted, the better alternative of prosecution in an Article III federal court. I believe that comparison was false, because just because the former, the military tribunal model, was an unprecedented violation of basic constitutional principles, the other, the criminal prosecution in federal court, seemed to me to encroach in more subtle but no less alarming ways on those same types of constitutional rights. And it also reminded me of my father's own legacy and long work in trying to directly confront many of the fallacies at the heart of the demonizingly impossibly large constructs like Islam and terrorism. I've now learned, I may be a little bit slow on the uptake, but I've now learned of these new things that they now call them scare quotes. I like that, especially when you see Islam between quotes, or terrorism, it's meant to scare you. And often the fear and hysteria associated with what has come to be known, even in the mainstream press, as Islamophobia, that fear and hysteria, they serve other agendas that seek to, I think, and I think this is part of, again, the legacy of my own father's work, these agendas seek to discourage popular participation and critical thinking in a democratic society about what the nature of the threat really is. And I think that we face this construct of Islamophobia with its stated goal to allow the state more liberties, to take away our own liberties under the rubric of fighting terrorism. And I think we do so at our own, I think that we allow the state to do that at our own peril. Well, I'll talk a little bit about my work in the Federal Public Defender's Office. That was because it was focused on a terrorism prosecution, but it also kind of gave me a real inkling about what it is that these prosecutions represent. So even in a case that was as large as the Larian prosecution, with many of the laws that I'm going to talk about, laws and practices like the material support law, and I'll talk about what that is in a second here. At its heart, I quickly became frustrated, because if you're making a motion, for example, right? Usually, especially if you're on the defense side, you make a motion and the judge just denies it, right? Because that's the way the system is kind of set up. And I kept wanting to delve deeper into the issues and continue to argue about them, because I felt there were some deep flaws here at the heart of the prosecution, its case, its theory of the case, the laws it was using, etc. So that led me to, after leaving the Federal Public Defender's Office, to focus on terrorism prosecutions as a kind of a study. And that culminated in my book, which Zaina mentioned to you, the Crimes of Terror, the Legal and Political Implications of Federal Terrorism Prosecutions. And the goal of the book was to document what I term a kind of terrorist exceptionalism to the normal rules of criminal law and procedure. So we see now our criminal justice system, the phenomenon of mass incarceration, the issues of police violence and racial profiling continue to occupy a very, very important space in the national discussion. And what I think the book tries to do is to talk about how, under the heading of fighting terrorism, we've seen the government kind of win some very significant victories and bring in tactics and practices that relax the normal protections a criminal defendant is entitled to in a prosecution. And so here, I would like to just give a few examples of some of the things that we've seen that establish this terrorism exceptionalism, and also, I think, when I kind of sum up, essentially allow the government to reach beyond the narrow terrorism context and change our notion of what it is to be in a liberal democratic society, our notion of freedom and our notion of activism and participation. I don't think we can underestimate the force of the phenomena and the legal rulings that we've witnessed especially in the last 15 years since the September 11th, 2001 attacks. So the book basically looks at the terrorism prosecution in a kind of linear way. So starting from the beginning, when the government decides to initiate an investigation, and then sort of tracks getting information from suspects, bringing a prosecution, what laws are used, what happens in the courtroom, and then what happens when someone, as usually occurs, although not always, is convicted and then sentenced and then sent. And you probably are not surprised to learn that there are special prison units for people who are convicted of terrorism crimes, even nonviolent ones. Okay. So starting from there, in beginning an investigation, what we've come to learn is that a lot of the investigations in terrorism-related prosecutions begin with the use of an informant. Now here it's very important to note, informants are people, in this instance, who have no pre-existing knowledge or suspicion of any criminal plot. Okay? So the classic construct in the criminal context is the police, the FBI, have knowledge that they catch someone selling drugs. And so they say to him, okay, you know what, if you tell us where you bought your drugs from, right, we will offer you a good deal, and you flip on them, okay? So in that situation, you would term the person who got caught not as an informant, but more as a kind of a cooperator, because he was involved in a pre-existing plot. In the terrorism context, the informant is someone who knows nothing, right? But the government finds them. Oftentimes we've learned, in fact, in the last few days, there was just an article that I read about how the FBI is exploiting people at the borders, right, whose immigration status is in some doubt or limbo, right, and asking them, they're usually from certain countries or certain backgrounds, and saying, hey, would you mind telling us things you know about what they're talking about in the mosque that you pray at, for example. Okay, so informants have no prior suspicion, no pre-existing suspicion that anything is going on, and the FBI take these people and they send them to mosques usually, or to look for people. And usually the informant plays a pretty active role. That's a kind of a euphemism. One would say concocts the plot, right, provides the means to carry it out. And we've seen that the number of informants that the FBI have employed, one investigative journalist looked into it and came up with a figure of about 15,000 in the September 11th, the post-September 11th era, are employed as or engaged as informants in the FBI's books, as opposed to about 6,000 beforehand. We also see part of what the criminal terrorism prosecution construct also engenders is a sort of knockoff effect in other areas of law enforcement. So now there was an article a few days ago in The Intercept about how the DEA, the Drug Enforcement Agency, employs some 18,000 informants, right? In addition, that also fuels related practices like the use of undercover police. Now, the police have always had, at least in the modern era, undercovers who go out and investigate activity. But on the other hand, we've now seen, I think this is a kind of related to the terrorism construct, we now see undercover police popping up in areas like the Small Business Administration has an undercover police wing. Okay, the Supreme Court has, it's been documented that they send out their own undercover Supreme Court police. I didn't know there was a Supreme Court police, but there are. And they go out and they spy on protests in front of the Supreme Court. So you can trace a line from this sort of idea that there is a threat out there, and the government needs to send people out to kind of uncover it, okay, and dig it up. And you've probably also heard phrases bandied about like radicalization that needs to be countered, or violent extremism that needs to be countered, countering violent extremism. So the government has invested heavily in these theories that the threat is out there lurking. And its identity, I think we sort of understand what they believe the identity to be, but we'll discuss this a little bit more in a second, or I'll discuss it a little bit more in a second. So that's how the investigation gets started. Now, what happens if someone is nabbed? We've seen also criminal justice protections kind of weakened as well. The one that I want to talk about here as we proceed along the line from investigation to interrogating a suspect is that of, there's an exception to we all know, I think, the Miranda warnings that the police are supposed to give you. You have the right to remain silent. Well, in the wake of the 2009 unfortunately named underwear bombing episode, where a fellow from Nigeria tried to detonate a bomb that he had hidden in his underwear, there was a lot of hand-wringing here in Washington, D.C., in Congress and law enforcement circles about the idea that if he were given the normal warnings that a criminal suspect gets about his right to remain silent, well, he might conceal more violent activity. Which is, I think, let's be fair, I'll try to be fair, I think conceptually, that is a concern that law enforcement has, that's legitimate, right? Of course, Congress, the FBI then went to Congress and said, okay, well, write us a law that gives us a Miranda exception. Congress didn't do that. So the FBI wrote its own memo where they talked about in certain cases where an individual has knowledge of an active terrorist plot, the FBI is allowed to interrogate that person without giving them warnings. Now, the question here is, how does the FBI know that? That's the sort of the old Dirty Harry problem. You remember the movie Dirty Harry? The idea that the guy knows the criminal, the criminal has someone hidden, and if Dirty Harry goes in and, roughs them up a little bit, they'll give it up. Those are some. I don't know that hypothetical always works, but let's assume that it does, and let's assume that it's valid, because I think there are situations we can imagine where dangerous people would want to do dangerous acts. That's fair. This issue kind of came to the fore in the public consciousness in the wake of the 2013 Boston Marathon bombings, right? Now, the exception to the Miranda warnings is I think, an important topic to discuss and debate, and the FBI articulated its point and granted itself an exception. The problem was that they not only did they didn't stop there. They went on to another situation where they, in certain instances where they feel that it would be of intelligence value to continue to interrogate someone without giving them Miranda warnings, the FBI says they can do that. And who makes that decision? Not a court, an FBI supervisory agent, and that's not something that's reviewable. So we went from a situation of public concern, which was an issue that people, I think, have a legitimate interest in being safe, and the FBI had, I think, a strong case. But they didn't stop there. They tacked on something else, where individuals who, even though they didn't pose any risk of future violence because there's intelligence value, in interrogating them, the FBI can proceed to go ahead. And the problem there with that is, if you take someone that you pick up, for example, that the government picks up between Somalia and Yemen, and holds them for 2 months at sea, and these cases like this have happened, holds them for 2 months on a naval warship at sea, and interrogates them, and gets all sorts of information, and then decides, you know what, actually you have the right to remain silent, and you don't have to say anything, nothing you say can be used against you. But you know what, you've told us all this stuff, why don't you just go ahead and say it again? I mean, are they going to actually say, no, actually I'm not going to admit to it this time? I mean, it's not a, I think, it's not a realistic construct. Even more alarming has been the idea that individuals who have been interrogated abroad by foreign intelligence agencies have had their confessions admitted here in the United States criminal prosecutions. So there's 2 examples, maybe because of time-related issues, I'll only give one. Many of you, or maybe some of you, have heard of the case of a fellow by the name of Ahmed Abu Ali, who grew up in this area, who was picked up in Saudi Arabia by the secret police there and interrogated. He ended up in this country after a lot of legal wrangling. But the heart of his case centered on his confession that he made. Okay? Now, he argued that he had been tortured. Okay? His interrogators in Saudi Arabia testified via video link from Saudi Arabia. And they said stuff like, yeah, we abuse our detainees. Yeah, I once tied a guy to a tree. Yeah, I've beaten guys, but I didn't in this case. Okay? And his confession was admitted, and he was subsequently convicted of the charges based on a standard known as the voluntary confessions test. Now, there's also a case of a Palestinian fellow by the name of Muhammad, Palestinian American called Muhammad Salah, who had a similar thing happen to him while he was in Israeli custody, and his confession was admitted. Now, I don't know that I'm the best person to be making arguments about American exceptionalism and the sort of pristine nature of the criminal justice system, but I can say that confessions in American law are guided by pretty strict standards, one of which is people, are entitled to at least consult with a lawyer if they want. They can waive that right, but when you're held, for example, like Ahmed Abu Ali was, for months, where you saw the consular official a couple of times, didn't have access to a lawyer, you're being held incognito, I don't see how that can possibly be a voluntary confession. Okay? Yet that precedent exists. That precedent exists. And the terrorism prosecution has brought it to us. I mentioned the material support law. The key law at the heart of these prosecutions is something called the ban on providing material support to foreign terrorist organizations. And it's mildly confusing, or it needs a little bit of explanation because there are several steps involved in it. Basically, in the mid-90s, Congress became concerned about the idea that in this country there were terrorist groups that were raising money under the cover of humanitarian activity to do violence. And so there needed to be a law that banned providing material support to foreign terrorist groups, even if those groups legitimately have charitable activities or humanitarian activities functions that they perform. The theory behind it is twofold. One is Congress articulated or made a finding that any activity a terrorist group carries out is so tainted, okay? Any kind of interaction with a terrorist group is so tainted by that group's violent activity that it becomes de facto support for terrorism. Okay, that's one finding that Congress made. The other is that money is fungible. Money for widows and orphans, charity, frees up money for bombs and weapons. Okay? And so Congress passed a law making it a crime to provide material support to a designated foreign terrorist organization. Now, to make the law active, there has to be a list of foreign terrorist organizations, okay? And that's done by the Secretary of State. So the Secretary of State designates a number of groups. There are now about 60 of these groups, there are three prongs to this. The group has to be foreign, okay? It has to engage in terrorism or terrorist activity, and that terrorist activity has to harm United States nationals or the national security of the United States, which is defined quite expansively, including, foreign interest relations of the United States. Now, that third prong about the terrorist activity harming U.S. interests, that is not something that can be challenged in court. In addition, there's no corresponding domestic terrorist list, right? There are only foreign terrorist organizations on that list. As I mentioned, there are 60 groups on the list. Now, I know I've talked a little bit about various aspects of terrorism prosecutions. When we come to the title of the talk and the sort of terrorism label, I think we start to get an idea of who the government believes to be the terrorist enemy, so to speak. So there's 60 groups on the list, 48 of which are Arab or Muslim in makeup or orientation. For the purposes of where we are today, 7 of those groups are Palestinian. 35, and in the more kind of modern formulation over the last 15 years, 35 out of the 38 groups that have been listed since September 11, 2001 are what you might call Islamist groups. Now, the interesting thing from a criminal law point is that the law itself criminalizes support. Now, usually when you look at criminal laws, the crime is evident. Someone assaulted someone killed someone raped someone. Okay, there's a sort of what we call a substantive crime. Here, the substantive crime is the support, or what you might call in the criminal terms aiding and abetting, is the actual substantive crime. So sort of on a conceptual criminal law theory level, this is an interesting law. Now, if you violate this law, if someone is charged and then convicted of providing material support to a foreign terrorist organization, you can be imprisoned for up to 20 years. Life in the case of someone dying, but there is no requirement that the government link the material support to any act of violence. Okay, just that there was material support provided to a foreign terrorist organization. And you've seen the more recent cases. I don't know how many of you follow these things. I do. My email inbox gets updates every few weeks. The material support law has been used over the last couple of years, year and a half or so, where individuals who are looking to go to Syria are charged with providing material support in the form of what is known as personnel themselves to go fight in Syria on behalf of this organization known as the Islamic State or Daesh or the Islamic State in Syria and the Levant, etc. There have been by the press reports in June of this year said that there had been about 90 cases, 90 prosecutions. And you read about them all the time. Okay, so that's the first clue that material support is not just money. Okay, it can be yourself. You can provide yourself as material support if you want to go fight on behalf of a terrorist organization. And if that were all we were discussing, maybe we would complain about certain inequities at the heart of the practice, but here's where the terrorism prosecution and the material support law starts to go to impact everyone's constitutional rights more directly. So first of all, it's not just money. In 2010, the Supreme Court decided a case called Holder versus Humanitarian Law Project, where it said that material support in the form of speech can be banned. So you can be prosecuted for providing material support in the form of what would otherwise be First Amendment protected speech. That case dealt with a situation where individuals wanted to help the Kurdistan Workers' Party, also known as the PKK, and the Liberation Tigers of Tamil Eelam, also known as the Tamil Tigers. They were U.S. citizens who wanted to provide support for these groups. And they said, you know what, we don't want to just forget money. All we want to do is advise these groups on how to use international law to peacefully advocate for solutions to their conflicts with the Turkish government and the Sri Lankan government. The Supreme Court said, no. People providing material support in the form of speech can be prosecuted for violating this law. So that's something that I don't think we saw coming in 1996 when the law was passed. The idea that material support can now come in the form of speech. One of the hypotheticals that the litigants in this case mooted was, what if they wanted to teach these groups, give them advice in terms of how to peacefully advocate, and they actually tied it to steering them away from violence, making these groups less violent. Nope, the government can prosecute them. Okay. The second example comes of what is material support, and the dangerous expansion of this concept comes from a case many of you might be familiar with. That's the prosecution of the former directors and executives of the formerly largest Muslim charity in the United States, the Holy Land Foundation for Relief and Development, based in a Dallas suburb. There, the government made an interesting point. So remember the money is fungible argument. There, the government initially charged these men and said that they were providing direct aid, material support in the form of funding, to the banned foreign terrorist organization under the list, Hamas, the Palestinian group Hamas. They were doing it by appealing to religious observant Muslims' sense of charitable obligation in the form of giving zakat. Okay, so they would give money to these, what the prosecution called zakat committees operating in the West Bank and Gaza, which were, the government charged, front groups for the Hamas organization. Now, again, we can think about it in terms of the Middle Eastern conflict, the Palestinian cause, but it doesn't stop there. And here's what I mean. When the case actually went to trial, the government backed off that theory. They didn't say money is fungible. What they said was, these groups, they're not part of Hamas. They're not front groups from Hamas. We admit that. But in the public consciousness in the West Bank and Gaza, they are associated with the Hamas movement. And so Hamas derives legitimacy from these groups receiving support. So the Holy Land Foundation was providing material support to a banned foreign terrorist organization by enhancing the group's legitimacy through the provision of unquestionable charity. The government never questioned that the money was going for actual charity. So here we have a new concept, material support in the form of legitimacy. A far cry from money is fungible. Okay? The Holy Land Foundation case is a particularly thorny one and a particularly difficult one to grapple with, because in addition to this expansive notion of support for terrorism and material support, other innovations took place. So, for example, what is it, because here we're thinking about what does the terrorism label really mean, okay? And I think we'll try to answer that question in a second. At the Holy Land Foundation trial, the government was permitted to use an Israeli security officer and have him testify as an expert witness. Okay, so please forgive me, I'm not trying to be pedantic. I don't know how many of you are familiar with the rules of evidence in federal cases, but a normal witness who comes up and says, yeah, I was standing at the corner of, 18th Street and Broadway, and I saw a guy, pull out a gun and fire 2 shots. Okay, he was wearing black jeans and a blue t-shirt, right? That's a fact witness. They're brought on to give facts. They're not allowed to give their opinion as to what happened, okay? An expert witness, on the other hand, is allowed to give their opinion. They're allowed to draw conclusions from the material. So in the Holy Land Foundation case, the government was allowed to use, it sought to have admitted as an expert, an Israeli security agent, okay, who testified anonymously, okay? What did this agent testify anonymously to? The fact that the zakat committees were linked to Hamas, okay? So the whole theory of the case hinged on this security agent who was testifying under a pseudonym. Now, if you know anything about expert witnesses, you also know that one of the main things that someone challenging an expert witness can do is get up there and say, okay, you said this, you wrote this, you argued this, but so-and-so disagrees with you. Aren't you wrong? And try to make that point to the jury. But if the person's identity isn't known, how can you do that? Okay? Even more amazing, and this is a point that shocks even mainstream legal commentators, so people who have no interest in terrorism prosecutions, the Palestinian cause, the Middle East, whatever, was the idea that there was a Supreme Court case precedent that dealt with anonymous witnesses. And the trial court in Dallas ignored it. The Court of Appeals, the Fifth Circuit Court of Appeals, brushed over the issue. What does an anonymous status, what does an anonymous witness mean? Okay, the anonymous status sends a message to the jury. It says, these defendants are so dangerous, right? They can't know who this guy is because their agents will threaten them, okay? And as I mentioned, it also allows no inquiry as to the witness's background. And that's where we are, right? In the years and the decades past, and I think my father, kind of bringing it back to his thoughts, wrote eloquently and trenchantly about the issue of the legitimacy of resistance to military occupation. That's at the heart of the Palestinian struggle. Okay. And that's where the debate was. But now, in this day and age, we're in a different sphere. The post-9/11 construction of the terrorist enemy, it doesn't allow for such discussions, right? Terrorism and its expressive dimensions, in the popular conscience, we're talking about groups like the Al-Qaeda phenomenon or the ISIS phenomenon. Once you're associated with a group like that, you're tainted beyond all hope, okay? Even if you're many degrees removed, okay? These stateless groups that don't have a popular mandate and use barbaric methods to fight basically guarantee that over here we cannot think rationally about things like foreign policy, okay? Or closer to home, criminal prosecutions and the problems at the heart of the criminal justice system. I mean, we have now the movement for Black Lives and the Black Lives Matter movements and related protests and upheavals in our society confronting police violence and mass incarceration directly, okay? But when we think about it in terms of this new, and forgive me if this sounds hyperbolic, obsession with terrorism, it allows the government to retain many of the tactics that are being challenged in the domestic sphere and have them stay viable and alive to maybe come back and haunt us on another day. This is something I think we need to understand and confront on its own terms, on our own terms. And I hope in my remarks that I've been faithful to my father's legacy in continuing to do so. Okay, and I'll stop there. So thank you.
Yes, my name is Eric Milans, and I was wondering if you could comment a bit more about the material conditions. To what extent do you have the impression some people are framed, right? This happens a lot in other circumstances like the DEA and drugs and planting evidence and so forth. So if we know that protections are limited for people who live overseas, you know, drones can just fire missiles at them whenever an imminent threat, however that is defined by somebody in a control tower in the United States, might occur, right? Similarly, the definition or the expansion of sort of material support, to what degree do you have not only problems with, as you indicated, the elasticity of the concept, but also just, you know, people stumbling upon things by clicking on websites and get prosecuted, or, you know, maybe simpletons, but other people just getting ensnared into sort of make-up schemes. Because if you're, you know, if you're employed as a police officer, you're supposed to do something, right? You're supposed to catch people, right? So.
Well, yeah, so it's interesting. I had looked into this point in some of my work on informants, And there's been a bunch of other work that's been done by both academics and investigative journalists who have looked into this. And the number of cases where the informant's actions are so provocative, where there's a case, you may remember the case, or you may have heard of it. It was in the news. This sort of the Newburgh synagogue bombing plot from 2009, I think it was. And then basically these were a bunch of young men who had been ensnared, I'll use your term, by an informant who basically suggested the plot, suggested the means to the plot, told them where to bomb, etc., and then delivered a controlled device that they were about to set off before the FBI swooped in. Now that's not, it's a problematic construct, because on the one hand, who would want to bomb a house of worship, right? It's not. But when you look at the informant's role in manipulating these men, one of whom was called, and forgive the use of this term because I don't mean to be insensitive, but his lawyer actually referred to him as mildly retarded. These were people, one person who was living, who was living on the margins of society in Newburgh, New York, which is already a very poor community. And I think the main argument that these individuals made, and by the way, there's a documentary made about this case called The Newburgh Sting. But, basically these are individuals who say, a guy comes and starts offering us tons of money to carry out a plot. Well, we're going to scam him, right? But that ends up with them being convicted of very serious crimes and spending many years in prison. And, I think there's a couple of things, I think there's a couple of points. One is that there's only one valid defense here that a person can make, which is you can make the argument that you've been entrapped. But entrapment is something that, as a legal strategy never works. It hasn't worked once in any one of these cases, and there are some reasons for that, but I don't know that I might go down that rabbit hole if I elucidate it too much, but it doesn't work for a whole host of reasons. And in addition, you also have things like the idea, and as I mentioned, there was an investigative journalist called Trevor Aronson who made the point that the FBI's budget is now, more than 50% of it is for national security related functions, more so than normal law enforcement, what they call ordinary law enforcement. So there's a lot of money being thrown at this problem. And I don't think it's unfair to argue that the terrorist threat and the sleeper cells, et cetera, are not, they haven't materialized the way the government threatened us with them. So there's a strong impetus to go out and find it. And when you think about also in the construct of radicalization being a phenomenon and violent extremism that needs to be countered, that's out there, that these individuals, mostly American Muslims, can manifest at any moment. They can radicalize at any moment. There's a strong impetus to go out and find them. And finally, in the last point, one point that I neglected to mention was these prosecutions are pushed by a post-9/11 mentality of preventive prosecution. So John Ashcroft first articulated this idea that we want to find the plots before they occur. But that presupposes that those people are out there hatching plots. And I think the evidence has shown that that's not necessarily the case. So that leads us back to this point of individuals who are placed in these positions where an informant who doesn't have any pre-existing suspicion goes and can kind of focus on the more weak and feeble-minded and marginal in society and get them trapped in a plot. So, sure.
I'd like to mention for those who have joined us online that you can tweet your questions to us at Palestine Center. Who would like to? Okay.
Could you speak to the extent? Could you speak to the extent in which these types of laws, material support, verbal material support, and so on, have been used to try to stymie the BDS movement in the United States?
The key element of the material support law is that it's support for a specifically designated foreign terrorist organization. So to the extent that I mean, there are people I think who understand this a little bit better, or study this more directly, but I think the BDS, the criminal prosecutions that I've read about have centered on sort of campus speech and stifling others, sort of obstructionist. So there haven't been, to my knowledge, material support charges that can be tied to one of those organizations. So I think, you know, I think that that, you know, while accusations that BDS activists are, you know, working on behalf of terrorist organizations exist, those allegations exist, they haven't materialized in charges to the extent that I know of. There was a case in Irvine, California at UC Irvine, and that was all about obstructing the Israeli ambassador at the time's right to give a speech. And I think that's what you've seen is like A, and then B, the other thing that I've read about is campus or university kind of speech codes are used to discipline individuals, but I don't think they get to the point of material support prosecutions.
Delinda.
Thank you. I think your father would be very proud of you.
Oh, thank you.
Is there any push that you know of to have President Obama commute the sentences of the Holy Land Five?
You know, I don't know about that. I know that what I do know about is one of the men convicted's daughter has been writing quite a bit about it, has written a bit about it over the years. I mean, you know, I think that anonymous expert witness issue, that was ripe for Supreme Court review. I mean, that was, you know, that was a tough one because I believed that it was an issue that was of such importance that it needed to be taken up. On the other hand, because of the case and the nature of the allegations, I didn't see much hope that it would. So there was a kind of a, you know, the intellectual side of me was saying it has to be taken up, but the sort of the person who follows the news saying no way. So I don't know much about those efforts. I mean, I think that, I mean, to be honest, you know, and I think I saw this also in the Ariane prosecution. You know, those prosecutions in general were you know, momentous and raised a whole host of incredibly important issues. And I think there was a real, what's the word here that I'm looking for? I don't know about a split, but there was some ambivalence, I feel, in the general, you know, community within the United States, because those people were identified as Islamists, right, in terms of who they were supporting. And I don't think the sort of bigger and broader issues of what the implications of these prosecutions were towards not just, you know, people politically active on the left or Arab Americans or Palestinian Americans, but, you know, an individual's right to advocate for causes they believe in it peaceably in the United States, peacefully. I don't think that was understood at the time. So I think that's probably also impeding a lot of those commutation, because I don't know about a larger issue, a larger scale attempt to commute the sentences of those men. Do you know? Okay. Okay. Yeah.
I'd like you to address the what I understand to be the separation of powers among the legislative, executive, and judicial branches. And in a domestic law, someone accused it depends on the jury decision, and the judge metes out the penalty. But in the case of informants questioning some terrorist, President Obama, as chief executive, we read in the paper, makes a decision for a drone to kill him.
Well, okay. So the question, I think, implicates. I mean, again, these are bigger sort of debates that lawyers and legal scholars and political types have about, you know, where does the Constitution go? Where does it extend? You know, and the idea that, you know, is there a Fourth Amendment? Are there Fourth Amendment rights outside the United States? You know, the answer has generally been no. And I think, you know, you see lots of, unfortunately in this case, creative lawyering about, you know, the ban on foreign assassinations in the context of drone strikes, that the idea of threats being expansively construed. So, I mean, I think the way I would look at that, because again, it's not an area that I focus in, but my understanding of it is that, and I think if you were to read up on things like executive power, you'd see that it's a lot of sort of policy arguments, because the actual limits of what the executive can do abroad are very much disputed, and a lot of times the way those issues play out is, you know, the president takes a decision to, you know, order a strike, and people argue about it afterwards. But can we conclusively say that under the Constitution something was illegal, that their legal action can ensue? I don't think so. I mean, that's a much more contested area of law. I mean, as much as on a sort of a personal level, you know, individuals or even a societal level, people might be very anxious about that and very uncomfortable with that. The idea of legal recourse is very hard to.
There are international treaties, some of which we've signed or ratified.
Yes.
That would raise issues.
Okay, I don't want to answer you. I don't know that. Sorry, I do want to answer you directly. I don't know that I can, but I can say this. So in the years that I've been teaching law, I've been taught a seminar in human rights, and the class inevitably every year is surprised to read about a treaty the United States has signed and ratified, the International Covenant on Civil and Political Rights. Because even though that treaty was signed and ratified by the Senate, you know, every so often, well, first of all, when it's signed and ratified, the Senate basically issued a whole series of declarations and you know, amendments and understandings that said, you know, things we disagree about this, we're just going to disagree. We've signed and ratified this, but if we don't want to implement whatever section, we just won't. And I think that is the mindset, and that's the sort of not just the mindset, but that's the practice in these matters when you have international treaties. I mean, the U.S. signed and ratified the Convention Against Torture. You know, I mean, did that provide any sort of legal recourse for individuals who had claimed to have been tortured by this country? You know, no. There have been no successful legal actions, and nobody's been held accountable for that. So, I mean, there's a kind of a disconnect between the formal stance and reality in that regard.
Can you hold on until we get
Do the overseas secret torture sites still exist?
Oh gosh, I don't know about that. I don't know. I mean, I'm just analyzing what's in the public sphere. I have no information about things like that. I mean, I think the way we, you know, we learn about these things the way everyone else does. You know, I mean, I think, well, I should say, I learn about it the way everyone else does. You know, there's usually some sort of government leak or government disclosure about, well, you know, there was a site in, you know, Poland or wherever there where the CIA did X, and you read about it, and you know, the government either confirms or denies or doesn't make a statement. And so, I mean, you know, I think the you know, because I haven't addressed the exceptional sort of legal system that, or the exceptional measures that we learned about in the wake of the September 11th attacks. I was much more concerned about what, you know, very, you know, well-read, learned, thoughtful individuals praised as the right alternative, which was the criminal prosecution. And my direct experience there led me to think that there was more here that needed to be analyzed and criticized, because it wasn't that smooth transition / good as opposed to bad alternative either or construct. So I haven't addressed those things because I think that this was an understudied area that really need, and I'm continuing to, write about it, and I'm actually hoping to get out the paperback edition of my book, which might have a new preface or conclusion. I haven't decided which. But yes, I mean, I haven't focused on that, and I don't know any way of knowing that. I just want to focus on what is known and proposed as the sort of better alternative.
That will be our last question.
Andre Ledoux, could you please contextualize this in historically, looking at stuff like Korematsu? I'm not trying to set up an argument, well, if this is better than Guantanamo, it's okay, or if it's better than Korematsu, it's okay. But I wasn't sure as you were talking about these issues whether you thought it was worse or just bad in a different way.
So, in respect to thank you for the question. With respect to the Korematsu and the Japanese internment phenomenon and historical experience, I try very hard not to kind of make value judgments about which suffering was worse or which, it just is a general point. But I think, I don't think it's unfair to say that Korematsu is a pretty low point in the courts, in the Supreme Court's history and in modern U.S. history. But I think part of that understanding also stems from the fact that it was a kind of an exceptional response in an exceptional time, which of course doesn't justify anything about it. But the idea of internment camps is so antithetical to what this country claims to stand for, that I think the experience is repeated sort of at the government's peril. I mean, we've over the years it's been discussed about how in the 80s, as a response to some of the terrorism crises that the Iranian hostage crisis and other attacks, the marine bombing attacks in Beirut and things like that. The government here, the Reagan administration, had the some immigration service officials draw up internment camp plans for Arab Americans, right, for people from Arab countries. It's still considered extremely controversial, and I think if there is a positive legacy of Korematsu, it's the fact that it is so beyond the pale to imagine internment camps on the basis of ethnicity and things like that. Here the issue is more that the government articulates larger theories about the nature of the threat under this scary monster called terrorism, which it's not to say that there is no terrorism in the world. It's just that once you take a phenomenon that exists and is violent, but is also can be, regarded a number of ways, and then you make it so broad that it starts to taint people, many degrees down the line, inevitably that's going to impact even the average person if the government wants it. And I think, so for example, in the Black Lives Matter context, one of the that type of police violence, it could be used against people of different ethnicities. It could be used against white Americans. The police have the discretion to do that. It's just they exercise the discretion a certain way. And I think here we're seeing a similar thing, is that these types of constructs can be employed to any and all political movements. It's just that the discretion is being exercised narrowly. But there's always a threat. This is one of the things where, I think, without sounding, I don't want to sound kind of hokey, but one of the things that a more modern sort of hero in this regard, Edward Snowden, said, which is, people are okay with this now, but what if the government changes? Maybe they trust the government now, but what if it changes? And that's what I think is that these are precedents that exist. How many Americans are being, tortured in Saudi Arabia and then brought here for trial? Not that many, but the precedent exists. And that's what I'm concerned about, is that the precedent sits there and stays valid to be employed for tomorrow's emergency. So I hope that answers the question.
Great. All these very difficult questions and policies, I think, make some of us feel a little fearful or paranoid. Our only consolation really is to know that people like you are doing this kind of work, Wadie. So thank you so much for your work, and thank you, and it's been a pleasure and an honor to have you with us.